Tennessee, at the Supreme Court, SCOTUS is hearing arguments on the state of Tennessee wanting to stop transgender care for minors, which I think is kind of idiotic we're even having to do this. It seems to me it's a no-brainer. Why would you let a 10-year-old, 12-year-old, 7-year-old, 8-year-old pick a number because they think they're not happy? What teenager is happy? We all know by scientific discovery, our brains aren't fully developed until we're 25? As far as the neurons and everything firing and the frontal lobe is fully developed on your stopping power, that's your superpower, which tells you don't do that. Right, but when you're younger, you act upon emotion, you act upon impulse, you act, I live for now, and most teenagers are narcissistic. They're all about them. They're worried about their hair, how they look, how other people perceive them. This is just basic stuff here. And here we have the court arguing over this. And you have, obviously, the idiot left trying to promote that, oh, little Johnny, she's going to bring this case up where some kid was so devastated that his own voice irritated him and he was just in total whatever psychosis over his gender, which is absurd. Something's wrong with him. Now, look, if you have, what is the percentage of the kids that are dealing with gender dysphoria, if that's what you want to call it? It's so minute. So you're just going to blanket this, and then you have other dumb parents, which there are dumb people out there who would do this to their children. Give them these puberty blockers, which is going to sterilize them. There's no coming back from it. So this is a no-brainer to me, and I'm just a little peon. A no-brainer to not allow small children to do this and not allow the parents to let them do it. So I know that they're arguing, well, should the parent, obviously the parents need to have control over their children, right? But parents don't have the right to let their kids drink or let their kids do dope or let their 13-year-old drive their car. So why would you let a parent mutilate their child, and their child just really has no clue of what kind of life what kind of person they're going to be when they're 25, 30 years old? They're going to be a completely different person. This, to me, it should be blanket across the board. No, you do not do this. If they turn 18, which you're still stupid when you're 18, when they turn 18, if they want to get tattoos or they want to go get a chakadika off me or add addictomy, whatever. But I think the argument is with the left is we want to hurry up and change them, get the damage done, convince them, well, if you start these puberty blockers, then you won't get the hair on the face if you're a boy. Start the puberty blockers on a girl so she doesn't get her breasts. So later on, oh, you won't have to get the breast surgery. You won't have to do this. You won't have to do that. And I think there's a huge percentage, and it's a story and that's yet to be even screamed out even more, that the high percentage of them have done this, regret this, because they are a different person now. They are different. Well, let's take a look and let's take a listen to what's going on here. Here we go. It's ridiculous.
We look to this Bostock type reasoning here.
So, oh, and by the way, it just jumped right in, so we didn't get the full question. So I don't know if there was some audio, obviously, on their end that just jumped right into the discussion and the debate.
So with respect to how to identify a facial sex classification in the first place, I don't think there's any relevant difference between the court's approach in Bostock and what this court has long done under the Equal Protection Clause. In both contexts, the court has made clear that the right to equal treatment is an individual right. So you look at the particular person and see how the law affects them. And the court in both contexts has already made clear that sex just needs to be one but-for causal factor. It doesn't have to be the sole reason or the primary reason. So for purposes of identifying whether facial sex classification is happening at the outset, we think it's equal protection principles as much as Bostock that carries the day, although of course Bostock reinforces those principles. You asked why this case isn't controlled by Geduldig and Dobbs. The court's reasoning there was that when you have a statute that doesn't classify based on sex on its face at all, the fact that the medical condition might be something that only one sex can experience isn't a basis to necessarily say that's facial sex discrimination. But that doesn't apply in any relevant respect here. First, because here we have the facial sex classification. The statute says no medications that are inconsistent with your sex. And second, these aren't drugs that are limited to one sex or another. Both males and females alike for decades have been prescribed puberty blockers, hormones, testosterone, estrogen. They produce the same physical characteristics, as I was saying to Justice Thomas, no matter whether your birth sex is male or female. So this doesn't look anything like pregnancy, where the court found that the medical condition itself was expressly limited to one sex.
Well, I'm not sure that's anything more than a play on words. Suppose a statute said, let's just talk about puberty blockers. Suppose a statute said that puberty blockers may not be prescribed or administered to any minor for the purpose of preventing the onset of puberty prior to the time when puberty generally occurs. Okay, that statute makes no reference whatsoever to anybody's sex. It applies to all minors. Would you say the same thing about that?
So I'm sorry, if I'm understanding the hypothetical correctly, the statute says you can't take puberty blockers before the time when you would ordinarily have puberty, so it's ruling out precocious puberty?
You cannot, no, it doesn't rule out precocious puberty. It rules out the administration of a puberty blocker for the purpose of preventing puberty from occurring at the time when it generally does.
I see. So if you're hypothesizing a statute where, in essence, the legislature is trying to get at the idea of prohibiting access to these medications for gender dysphoria reasons or otherwise, then maybe you would apply an Arlington Heights type of analysis. But of course, that kind of law that you're hypothesizing would also prevent people from taking puberty blockers if they have cancer and want to preserve their fertility, because it would prevent them from undergoing puberty at the ordinary time. I think that's why the legislature hasn't tried to circumvent a facial sex classification by drafting a law like that. It would have many other applications that the state might not want to aim at. That's very different from a law like this, where the state was being clear, we only want to prevent the medications when it's inconsistent with sex, and we're doing that because we have an interest in having minors appreciate their sex and not be disdainful
Well,
of
let
their
me
sex.
ask one final question that addresses Geduldig and Dobbs. Let's take Geduldig first. One could make the same argument in Geduldig that you've made here. A man cannot, which concerned whether a pregnant woman was entitled to disability benefits for time missed at work, when a man would be entitled to benefits for time missed at work. So in that situation, a man cannot work due to a medical condition that prevents him from working. He gets benefits. The woman cannot work due to a medical condition, pregnancy, that prevents her from working for a period of time. She doesn't get benefits. It's the same argument you're making here. Or we could do it in Dobbs. A man who has a medical condition that causes physical and mental distress and pain and limits his daily activities can get a corrective medical procedure. Let's say it's a hip replacement. But a woman who has a medical condition that produces similar consequences, namely pregnancy, cannot get an abortion. So you can make exactly the same argument that you make here under Geduldig and under Dobbs. And yet there was no equal protection problem in either of those cases.
And that's because the court said that there was no facial sex classification insofar as using pregnancy does not automatically mean that that's a proxy for sex. But here there's a facial sex classification. No one can take these medications if it would be inconsistent with their sex, and that's imposing on the face of the statute two parallel rules on classes of people according to their sex. All adolescent males who want to take these medications to feminize their bodies, and all adolescent females who want to take these medications for masculinizing purposes. That's a facial sex classification through and through,
All right.
and I don't think it's controlled by Dobbs or Godoldig.
Thank you, General.
Justice.
Yeah, but it should boil down to minors, period. Minors is minors. We don't specify that we're going to discriminate against male and female if the boy wants to go buy liquor. He can't because he's a minor. He's under 21. The same is for a female. She's not going to be able to go buy alcohol because she's 21. Minor is a minor, period. Yeah, it just kind of drives me nuts that they have to dance around this. Let's specify that you're being sexist. That's what I'm getting out of that libtard woman. I don't know how she sleeps at night trying to get past a bill to butcher children.
Sotomayor.
General, just to
Sotomayor.
unpackage some of this argument, your point, I think, is very clear that Bostock is pertinent only to the extent that whether it's Title VII or the Equal Protection Clause, the first question is the legislature using sex as a classification, correct?
That's right. So our argument is that when you're looking for whether there's a facial sex classification under the Equal Protection Clause, it has always been the same but-for causation principles. And of course we agree with the logic of Bostock, but we think that that logic carries over in this context where the court has already said it just needs to be one but-for cause. It doesn't need to be the only cause. And one way you look at that is seeing whether the application of the statute changes when you change the person's sex.
Now, Bostock is very different than this case because in Bostock, what we said is if you use sex at all, unless you have a statutory exemption, you can't do it, correct?
Exactly. And I think that's an
here,
important...
Under the Equal Protection Clause, we recognize there are inherent differences between the sexes.
And that can sometimes provide a legitimate basis for classification.
That's the point.
So you're exactly right. The standards for liability are different. Under Bostock and under Title VII, you can't use
With
sex.
respect to the discussion about the European countries and the fact that they haven't limited these treatments altogether, the Cass report, as you point out, explicitly says that medical intervention might be necessary for some adolescents, correct?
That's right.
And that is recognized by all the European countries, correct?
Yes, I think it's reflected in
Do
the
we
laws of
care?
those countries which have not outright banned the care.
Isn't the purpose of intermediate scrutiny to make sure that we guard against I'm not intending to insult, but we all have instinctual reactions, whether it's parents or doctors or legislatures, to things that are wrong or right. And for decades, women couldn't hold licenses as butchers or as lawyers because legislatures thought that that we weren't strong enough to pursue those occupations. And some people rightly believe that gender dysphoria may be changed by in some children. But the evidence is very clear that there are some children who actually need this treatment, isn't there?
Yes, I think the evidence is uniform on that, whether you look at the standard of care, whether you look at the view of every major American medical association that has taken a position, many of whom are amici here. It's reflected in the clinical practice. The nation's leading children's hospitals for decades have been providing this care.
Some children suffer incredibly with gender dysphoria, don't they?
Yes, it's a very serious medical condition.
Some attempt suicide.
Yes, the rates of suicide are striking, and it's a vulnerable population.
Drug addiction is very high among some of these children because of their distress, correct?
It is a serious condition,
One of
yes.
the petitioners in this case described throwing up every day, going almost mute because of their inability to speak in a voice that they could live with. These are
To me, that's somebody with some serious mental issues. You're gonna want to throw up and be shaking and disillusioned of the sound of your own voice. There is something wrong with you, like mentally wrong with you. It's not the thing that, oh well, let's solve the problem by just butchering him. I mean, if he's a child and he's gonna go through puberty, obviously he does need some mental help and being under mental supervision. And just wait. Yeah, he's just gonna have to suffer through it, bite the bullet, suck it up, buttercup, until you go through puberty, because puberty can cause all kinds of things. Like I said, it doesn't take a rocket science. Everybody remembers when they were a teenager. A lot of us were depressed. Some days you felt great. Some days you didn't. You're worried about what other people think about you. You're worried about what your hair looks like. You're worried about that are you wearing the right clothes. I mean, all of this is normal, kind of normal, but what she's describing is not normal. And it's such a minute percentage, it's not even on the Richter scale for us to just say, let's just do this. And why do we care if the European countries are butchering their children? We should set an example and go, no, we're not going to butcher our children. We're going to get them the mental health that they deserve.
physically challenging situations as well, too. Correct?
Yes, that's correct.
And isn't the purpose of intermediate scrutiny, the level of scrutiny that we apply, necessary to ensure that whether it's legislatures or this court, that we don't make those personal judgments, but that we subject the judgments about these issues to a heightened review to ensure that those children who are going to suffer all of these consequences will be made to do so only when it's compellingly necessary.
The way she's talking, we already know how she's going to vote. Just by the stupid questions that she's saying and her making the comments. And her, well, there are children who suffer. I mean, it's kind of obvious.
Yes, in a circumstance where the state has an important interest. And we don't think that that means the states are entirely barred from regulating in this space. Obviously, they are grappling with these issues in a variety of contexts. But you're right to say that when the state is using sex-based line drawing, a court needs to look at that. And the problem with Tennessee's law here is not that it's just a little bit over-inclusive or a little bit under-inclusive, but that it's a sweeping categorical ban where the legislature didn't even take into account the significant health benefits that can come from providing gender-affirming care, including reduced suicidal ideation and suicide attempts, and where the state leaves unregulated entirely access to these treatments in all other pediatric contexts where there's a similar risk-benefit trade-off. And for the families affected by this, Justice Sotomayor, these are difficult decisions. Obviously, anytime you're thinking about a medical intervention, you need to weigh risks and benefits. But the state has come in here, and in a sharp departure from how it normally addresses this issue, it has completely decided to override the views of the parents, the patients, the doctors who are grappling with these decisions and trying to make those trade-offs.
Thank you.
I think the problem is because it's irreversible. Yeah, they might be depressed now and miserable, but it's irreversible. And they're going to be a different person when they're 25, 30 years old and go, oh my God, now I have a change of mind. I would love to have children. I cannot have my own children. This is a problem. This is why I'm against this. That people change. We all change. We can change our political views, our religious views. We all change. We all evolve. And that's the issue, is that this is irreversible. Okay, they're suffering now a little bit, but they're going to get through it. What happened to take on responsibility, get help for the issues you have, and it's not to go get puberty blockers and get a surgery. A pill, all of this stuff is not the answer to our depressive problems.
Justice Kagan?
General, I wanted to get your thoughts first on why one should think of this as primarily a sex-based classification. Because there's another way of looking at a law like this, maybe a more obvious way, which is that it's a classification based on transgender status. In other words, there are trans young people on one side of the line and cis young people on the other side of the line. Both male and female on both sides of the line. And why what is really going on here, I understand the formal ways in which this is a sex-based classification, but I'm wondering whether that's not a little bit formal. And what's really going on here is discrimination against, a disregard for young people who are trans, and why we shouldn't think of the law in that way.
I think you can conceive of the law in that way, and we certainly do think that this law discriminates on the basis of transgender status, and that likewise should trigger heightened scrutiny, both because that's inherently a sex-based classification and because we think transgender status discrimination warrants heightened scrutiny in its own right. But
why is transgender a sex base? They're either male or female. I don't care if they dress up as a woman or a woman dresses up as a man. They're still men and women. Transgender should not be classified as a sex. This is ridiculous. Maybe I'm misunderstanding what they're saying, but that's what it sounds like. This is classification of sex because the transgender community. Blah, blah, blah. I mean, transgender is not a sex. It's just a guy wanting to be a woman or a woman dressed up as a guy. They're still the sex they were born with. I don't even care if they took hormone treatment or they got puberty blockers or they got the surgery. They're still born what they were born. So 1,000 years from now, 100 years from now, somebody digs up their body, are they going to go, oh, they were transgender? Like, no. They can tell by your hip bones, your shoulder bones, all your bones, what sex you were. What sex you were born at. What sex you were when you died. It's not that you were transgender. Are you going to put something on your tombstone so somebody could get your pronoun right when they dig you up? I mean, come on. Anthropologists will go, oh, they were transgender. It is a new sex.
I don't think it's unduly formal to look at this as a sex classification, and the reason for that is because of the first operative provision of SB 1, which says you can't have these medications to live or identify in a manner inconsistent with your sex. That is quintessentially imposing sex-based rules and expectations on adolescents in the state, and it's true it arises in the context of medical care for transgender youth, but here we think it's a very straightforward path for the court to look at that and say, well, in any other context, when you say you can't do something inconsistent with a protected characteristic, that's obviously classifying people on the basis of that characteristic. And here it wasn't accidental or incidental. This is threaded throughout the statutory scheme because the legislature was quite upfront that part of the interest here is in ensuring that minors appreciate their sex and not become disdainful of their sex, or as Judge White put it in dissent below, that they look and live like boys and girls. And I think that adds on an additional layer of sex classification here insofar as it shows that part of what the state was attempting to do is ensure that adolescents conform their bodies to the state's physical expectations of how males and females should appear. It's not at all surprising to think of that as a sex classification.
So is what you're saying is that the two are just embedded in each other, or is what you're saying that sex stereotyping is built into our understandings of trans and cis classifications? Or again, is that this more sort of logical analysis that might be found in an opinion like Bostock. And maybe those are not exclusive, but what's your sense of that?
So I think those aren't exclusive. I think they're reinforcing here. And I guess what I would say is I think this is an even easier sex classification than maybe the one the court confronted in Bostock, or the one the court would confront if the statute simply discriminated on the basis of transgender status, because here the legislature actually put the sex classification into the face of the law and made the first order restriction here one that prohibits inconsistency with sex. And I just go back to the kinds of examples we give about dressing inconsistent with sex or pursuing a profession inconsistent with sex. I think the court's recognition that that is a sex classification is obviously right, but it also can build in a layer of conformance with sex stereotypes that might be underlying those laws and that we think equally underlie this one.
So let me flip now to what it means to do heightened scrutiny in this area, because as you point out, this law, and I think almost all of the similar, or maybe all of the similar laws that have been passed like this, allow this exact same kind of treatment for the opposite purpose, if you will. For a person born male who wants to get to puberty already,
Right.
And you say that that's a kind of under-inclusion problem. And, it strikes me that on formal equal protection analysis, it is, unless the state can come forward with some piece of medical evidence that says that the risks are greater in the one area than in the other area, which you say Tennessee has not done. I guess what I'm asking is, isn't the structure of these laws going to mean that all of them are going to have to be struck down once you get to heightened scrutiny? Because you seem to want to say, no, you can do heightened scrutiny, but you can also make certain deferential moves towards the legislature. And I guess I'm pressing you on whether that's really true.
So I think it is true. To be sure, we think that a categorical ban like this one is severely under-inclusive and also severely over-inclusive, which is an important ingredient here, and so should be invalidated. And if other states likewise have this kind of sweeping ban, then they would fail under heightened scrutiny. But I don't think that means that heightened scrutiny ties the hands of the states in this regard. One of the problems with the state's approach here is that although it has targeted this gender-affirming care for disparate treatment on the basis of sex, as we say, it has left these exact same medications entirely unregulated for all other purposes, and also turned its back on how it handles the risk-benefit calculus with respect to all other pediatric treatments. But we do think there is a real space for states to regulate here, and I point to the example of West Virginia. West Virginia was thinking about a total ban like this one on care for minors. But then the Senate Majority Leader in West Virginia, who's a doctor, looked at the underlying studies that demonstrate sharply reduced associations with suicidal ideation and suicide attempts. And the West Virginia legislature changed course and imposed a set of guardrails that are far more precisely tailored to concerns surrounding the delivery of this care.
Yeah, they'll end up wanting to kill themselves later. So maybe we're going to delay their suicidal thoughts now. Oh, I'm kind of happy for a moment. Or I got pleasure from this. Maybe. Because the difference between happiness and pleasure is two different things. Young people can't even distinguish love from infatuation. So you're having these thoughts, you want to kill yourself, and then, oh, now Mom's going to take me, and I'm going to get all these puberty blockers, and then I'm going to look female, and then they got to take scrutiny from their peers. Kids are cruel. So they're going to endure that, and then maybe it'll hesitate the thought of killing themselves, but then once they reach a certain age, then they'll go, my God, what have I done? I'm going to keep saying this. How many of you that are over 40, over 30, whatever, in their 50s, had thought back and went, man, was I a dumb ass? Man, why did I do that? Why did I do this? I was stupid. And I wished I didn't do this. I wish I didn't do that. I mean, we've all, it's inherent. It's how it is. It's in the books. That's it. And so we're going to postpone the thought of committing suicide, but then later on, it's a possibility that they have such regret that they're going to want to commit suicide.
Is medically necessary to guard against the risk of self-harm. The West Virginia law also requires mental health screening to try to rule out confounding diagnoses. It requires the parents to agree and the primary care physician to agree. And I think a law like that is going to fare much better under heightened scrutiny precisely because it would be tailored to the precise interests and not serve a more sweeping interest like the one asserted here in having minors appreciate their sex.
Thank you, General.
Justice Gorsuch? Justice Kavanaugh?
First, want to ask about our role here and pick up on the Chief Justice's questions at the beginning. Who decides? You've put forth forceful policy arguments to allow these medical treatments, and Justice Sotomayor's questions elaborated on that. But the 20-plus states on the other side put forth very forceful arguments against allowing these medical treatments for minors. So it seems to me that we look to the Constitution, and the Constitution doesn't take sides on how to resolve that medical and policy debate. The Constitution's neutral on the question. At least that's one way to look at it. I want to get your reaction to that. If the Constitution doesn't take sides, if there's strong, forceful, scientific policy arguments on both sides in a situation like this, why isn't it best to leave it to the democratic process?
Well, I do think that the Constitution takes a position that individuals are entitled to equal protection of the law. And I totally understand the force of your intuition that states need space to regulate and to try to take into account concerns like adolescent health. We're not denying that that's an important interest here. But when you look at how this law actually operates, what it is doing is denying individual plaintiffs the ability to access medications on the basis of their sex. And that doesn't mean that the states are disabled from taking into account the actual biological differences between males and females, but that has to be channeled to the heightened scrutiny stage. And I think that there would be a real danger in this court saying, looking ahead essentially and saying, we think there might be benign justifications here, or we think that states should have some flexibility in this regard to overlook the facial sex classification in the statute. If you are concerned, Justice Kavanaugh, about moving too fast in this space and maybe restricting the ability of states to take a close look at these issues, I think the court could write a very narrow opinion in this case, and the court could say simply that when you prohibit conduct that's inconsistent with sex, that is a sex-based line, so you do have to apply heightened scrutiny. But the court has made clear that that's an intermediate standard, and if the state can come forward with an important interest and substantiate that it needed to draw those sex-based lines to substantially serve the interest, that's going to be okay.
Keep going, sorry.
And the final point is that you can send it back and let the Sixth Circuit grapple with this in the first instance.
On the sex discrimination point, I guess picking up on Justice Kagan's questions, I mean, the way you would think about this is, I guess, it prohibits all boys and girls from transitioning using certain medical treatments, and it doesn't say only boys can do so or only girls can do so.
Well, I think the problem with trying to put that transitioning label on it as a basis to avoid the sex classification is that transition itself is inherently tied to sex. In other words, the prohibited purpose here are those treatments that would allow a minor to live and identify inconsistent with sex, and the statute would permit anyone to have those treatments for the non-prohibited purpose, which again is when it's consistent with sex. The court has said many times that labels don't control in this space, and I think when you have that kind of purpose that's expressly defined using sex-based line drawing, you have to recognize that for what it is.
And no matter how you articulate the standard, whether it's rational basis or intermediate scrutiny, it'll come down to whether the state, and I think you said this, has sufficient justification for limiting these treatments for minors. And the state says its justification here is health and safety for minors. You say there are benefits from allowing these treatments, but there are also harms, right, from allowing these treatments. At least the state says so, including lost fertility, the physical and psychological effects on those who later change their mind and want to detransition.
There's no going back.
I don't think we can ignore. We can't ignore what you're talking about and what Justice Sotomayor raised. I agree with that, but you can't ignore, I think, the risks on the other side of the balance. So even if it is intermediate scrutiny or rational basis, those justifications for the state, how do we as a court choose which set of risks is more serious in deciding whether to constitutionalize this whole area?
Good point.
So let me react to a couple of different points you brought up. First of all, I do think that the standard of review very much matters. And the court has made clear that rational basis is an entirely forgiving standard. It applies to mundane economic regulation where there's no reason for courts to take a closer look. So I think the court should hold the line that anytime the state classifies based on sex, you do need to take a look at that. But I totally take the point that, of course, when a state is coming forward with an important interest like protecting adolescent health, that may well justify the lines the state has drawn. And it's not about asking courts to step in and make a first-order determination about how to weigh risks and benefits. But I do think that the state is under a basic obligation to first substantiate its concern, and here there were extensive factual findings by the district court that many of the risks that the state was asserting are not uniquely tied to gender-affirming care at all, and also to take into account the harms that would come from categorically banning access to medications on the basis of drugs, including the benefits that I was discussing with Justice Sotomayor. You mentioned fertility and regret, and I'd like to take both of those concerns head on. I do want to acknowledge that there is evidence to suggest that gender-affirming care with respect to hormones can have some impacts on fertility. Critically, puberty blockers have no effect in and of themselves on fertility, so I don't think that concern can justify the ban on puberty blockers, which is just pressing pause on someone's endogenous puberty to give them more time to understand their identity.
That's not
With respect to hormone use, there are some effects on fertility, but the court found that many individuals who are transgender remain fertile after taking these medications. They can conceive biological children. There are fertility preservation measures that they can undertake, and that they have to be counseled on those risks. And as I said before, I can understand that that could be a hard trade-off, but it's not unique to this care. There are other treatments for adolescents that likewise affect fertility, including some of those that SB 1 expressly permits, like on intersex individuals who often have surgeries as infants that might permanently affect their fertility. I would also say that if you are concerned about fertility, there are measures the state could undertake, like requiring warnings, more informed counseling, trying to ensure that there's informed consent in this area. You also mentioned the possibility of regret. The record evidence demonstrates that the rates of regret are very low because for the population that has access to this treatment, so these are adolescents who have marked and sustained gender dysphoria that has worsened with the onset of puberty, they are very likely to persist in their gender identity. But if you're thinking about this from the standpoint of there's no harm in just making them wait until they're adults, I think you have to recognize that the effect of denying this care is to produce irreversible physical effects that are consistent with their birth sex, because they have to go through puberty before they turn 18. So essentially what this law is doing is saying we're going to make all adolescents in the state develop the physical secondary sex characteristics consistent with their gender or with their sex assigned at birth, even though that might significantly worsen gender dysphoria, increase the risk of suicide, and I think critically make it much harder to live and be accepted in their gender identity as an adult. Because if you're...
This is stupid. Kids could not make this kind of call. A life-altering call. What parent is going to want their kid to do this to themselves? And she's just spewing this nonsense. Are you kidding me? Well, it's a tragedy if you let them go through puberty and then, okay. I mean, if you're going to let kids make these kinds of decisions, what other kind of decisions are going to come down the pike? I'm just throwing this out here because we know same-sex marriage just opened up the door for trans people. It opened up another door. It opened up Pandora's box. Now transgenders want to go in women's bathrooms. Transgender men dressed as women, go in women's bathrooms. So what's going to happen down the road? Now we're letting adolescents make these decisions. What's down the pike? What kind of decisions can they make? Is this going to be some kind of Nazi dystopia where rat on your parents? make these decisions, well, I'm not happy with them. Take me out of this house. They're not letting me do what I want to do. Are they going to be allowed to make a decision to take drugs before they're 18? Now, we all know kids that do drugs, but they always hid it from their parents. Come on, guys. I grew up in the 70s and 80s. The thing is that, there's some things you just don't let your parents know about. But look, I'm just saying, I think this could open up Pandora's box on what else are we going to allow these young people to make the decision or allow their parents to make these decisions. So either they're going to get to a point where it's between the kid, the parent, and the doctor. They're going to make a decision. But see, the kid's listening to all this and getting confused with all the gobbledygook, and they're going to go, okay, and then they all look at the kid and go, okay, now what do you want to do? And they're like, how are they supposed to understand all this bullshit? You're going to be a different person in 10, 15 years. What are you doing?
If you're requiring someone to undergo a male puberty and they develop an Adam's apple, that's going to be hard to reverse, and they're more likely to be identified as transgender and subject to discrimination and harassment as adults. So I think the relevant question is...
Wait. I thought transgenders were their own sex, and why? How come you're saying they're getting discriminated against? Nobody gives a shit about transgenders. What do you mean they're discriminated against? They're discriminated because they don't want them going into women's bathroom. Hey, 30 years ago, I knew all about transgenders. They used to have drag queen shows and all of this stuff. Nobody cared. There wasn't people protesting outside the club at midnight when they were having their show because it was for adults. The problem is when you stick it in the face of children. So now you're throwing this straw man argument that he's got an Adam's apple, so now he's going to be discriminated against. Okay. I'm going to wrap this up, do a part 2, because they still have another hour of yapping, and I don't know why it cut right in there. Maybe it was the Fox News channel. I don't know. I'll have to research it to see if there was the front part that I missed. But so far we've heard arguments from the lib side who wants this, who wants to mutilate our children. They're part of the woke culture. I think this is a big problem. This could set a precedent throughout America. And then I hope they make the right decision that this is, unless they shoot it back down and say, hey, y'all figure it out in your own state. I mean, they did, and then they took it to the Supreme Court, so I don't know, I'm just guesstimating, but there you go. Please like and subscribe, and wait for part 2.